to meeting number 15 of the House of Commons Standing Committee on the Status of Women. Today's meeting is taking place in a hybrid format pursuant to standing orders, and members are attending in person in the room and remotely using the Zoom application. I'd like to make a few comments for the benefit of members and witnesses here today. Please wait until I recognize you by name before speaking. If you're participating by Zoom, you can click on the microphone icon to activate your mic, and then please mute yourself when you're not speaking. For interpretation on Zoom, you can select the appropriate channel at the bottom of your screen, either English or French or the floor. And for those in the room, you can use your earpieces. You all know how to do it to protect our interpreters. If you wish to speak, raise your hand. And for those on Zoom, please use the raise hand function if you do want to speak. And all comments should be addressed through the chair. Thank you for your cooperation. So pursuant to Standing Order 108-2, and the motion adopted by the committee on Monday, September 15th, 2025, the committee will resume its study of Section 810 of the Criminal Code and women's safety. Before we welcome our witnesses, I would like to provide a trigger warning. We'll be discussing violence against women, and this may be triggering to viewers with similar experiences. If any participants feel distressed or need help, please advise the clerk. And for all witnesses and all members of Parliament, it's important to recognize that these are difficult discussions, so let's be compassionate in all of our interactions. I'd now like to welcome our witnesses by video conference, la Fédération des Maisons d'Hébergement pour Femmes, Manon Monastès, Directrice Générale.
General Director, and Julie Saint-Pierre Gaudreau, Geopolitical Advisor.
Not yet, she's on her way. We have another witness after that. Alors, nous commençons par les déclarations préliminaires.
We will begin with preliminary remarks. We will start with the Women's Shelters Federation. You have 5 minutes. Yes, hello. I'll give a quick overview of our organization. It's a provincial association. We have 37 member organizations that represent first step emergency women's shelters as well as second step shelters. Its singularity is that there's an intersectional feminist approach. That means they'll accompany women who have experienced all kinds of violence on the violence continuum. It can be IPV, sexual exploitation, sex trafficking, etc. For your information, for 2024, our members accompanied over 2,000 women and many children. That represents around 40,000 calls on our 24/7 hotline. Today, we really want to tackle the issue of Article 810 of the Criminal Code, so the commitment to not disturb public peace. What we've really noticed on the ground is particularly issue about breaking the conditions in Article 811, and that's not treated the same way as most other criminal infractions. There's a worrying increase of violating conditions, especially in Quebec. In 2024, it was about 11,000 breaking of conditions, and that's only breaking conditions that were signaled. So it's really just the tip of the iceberg. That's everything that was recognized by the police. However, we know that many police will not take breaking conditions into account under Article 811. And that's compared to 4,000 previously, so it has significantly increased. And what we've realized on the ground is that there are multiple refusals of recognizing breaking conditions by police. And so it depends on the region and the resources available according to the police squad. That's an issue in and of itself. Multiple shelters have said there's an issue in terms of police officers who encourage women to do the legal process themselves and to represent themselves. But when the police agents do the process and understand that there's a security issue for women who are victims, then it's much easier for the victims and more recognized legally, so that can have a big impact on the victim's experience in the justice system. And that removes some of the administrative load on the woman victim. That was about that, and I will let my colleague conclude. Yes, and I'll follow up on what my colleague said. In terms of breaking conditions under 810, when there's a break of condition under 810, it should automatically be 811, which is already a criminal act. That's not applied very often, among other things, because there's a management of non-respect of conditions. 1 minute left, all right. And the evaluation of the danger level by police, the Quebec government, in the last report it did on the subject, indicates that in all cases studied, there was a history of domestic violence towards the victim. More than a third of the situations had previous incidences that were reported. So it's a major issue. It's a major issue of police practice in terms of what to do when there's a break of conditions. We know in a domestic violence context, it is absolutely critical. A woman was killed by her partner. Her partner had broken his conditions over 20 years. He broke his conditions 16 times. So there's really a major issue in terms of what we need to do practically, because we need to practice 811. We need to use the tools that are available. And we can evaluate breaking conditions. It should automatically be a criminal offense and involve detention. Thank you. Thank you. So we'll start with a round of questions with Madame Vien, 6 minutes. Madame Manon, I'll let you finish what you were saying, maybe for a few seconds. Yes. What we were saying is that, yes, we need to reevaluate breaking conditions. We need to reevaluate. Why is there no management? Why is there not an automatic response on behalf of the police force? What we see on the ground is that they'll evaluate, yes, but it's just a message, yes. When concretely, in terms of the law, it is a criminal offense in and of itself. And among other things, we need to mention in the Guide of Police Practices, or rather, it needs to be enshrined in the guidebook on police practices. Thank you very much for being here and making yourselves available. Madame Monastes, I'm going to follow up on what you said, and you're quite specific on the break of conditions. Recently on the radio, you said in the 30 years that you've been working in the sector, you've seen it regularly over 30 years, breaking conditions. But now it seems like we're in a situation where it's just exponentially increased, where it's become the norm, it's normalized. You gave the example of a situation where there were 93 violations of an 810, Article 810. According to you, when should the law intervene? And what should we do at that time? When there's a situation where there are 93 breaks of conditions, how does this happen? Yes. We must apply the law. When there's a breach of conditions, well, it ought to automatically become an 811 and entail incarceration. It ought to also bring about a criminal infraction. Let's say it's for assault, threats, but when there's an 811, well then it'll be treated like another issue. But it's really not used very often. If I may, you said 96, but we said 16. We were talking about Gaby Renault. For Gaby Renault, it was 16, but you referred to a specific case on the radio. There were 93 breaches of conviction? Yes. Yes? There was a situation where there are 93 breaches of condition. I don't have a lot of time. We have two laws, C5 and C75. I know you're very informed. Don't you think that those two laws have made it there's a kind of lack of rigor, especially in terms of parole, of men generally in terms of violence against women? Letting these men out of prison when they shouldn't be let out of prison, on top of what you're observing in terms of the 810, has this endangered women's safety? In terms of a bill, we had some hesitations. However, I believe that fundamentally it's a question of evaluating the level of danger that ought to be done, regardless of laws, and that is not done. Evaluating the danger level during bail hearings, well, that's done. But if the accused doesn't want to go through it, he doesn't have to. But in a domestic violence context, we must be able to do the evaluation of the level of violence. And not simply not do anything based on multiple breaches of condition. Well, we're seeing incredibly sad things happen. You mentioned Madame Renault. We can also talk about Madame McCourt. In effect, it's terrifying. And there's a principle of restraint at the moment. The Minister of Justice has said that there's an increase of crime. And that doesn't remove the principle of restraint. The conservatives, we say, well, we should take the victim's side and go with the principle of safety. Don't you think that would be more useful? When guys get out after 16 times breaching their conditions and then kill a woman, shouldn't we try another approach? We should, above all, have a better framework. There are limits to the law, but we must have a better framework. What happens when they're in there? The murderer of Madame Renault went to prison, and what happened? Madame Gaudreau wants to add something, so I'll add time there. Well, she could have finished, but what I wanted to mention is above all that what we're hearing on the ground in terms of the evaluation after C5 and C75, we haven't really had a pertinent evaluation in terms of the impact of those bills. So it's easy to make the link, but there isn't much data to support that, just to follow up on what Manon said. In fact, it would be more relevant to apply tools already at our disposal. The 811 is already available.
We're going to go now to Ms. Khalid for 6.5 minutes. Thanks.
Thank you very much, Madam Chair. Merci pour votre participation.
Thank you for your participation. I'm working on my French.
I want to talk a little bit about both of something that you've touched on is the difference between creating laws and regulations like Bill C-5, like others, and then the enforcement thereof. And I want you to perhaps kind of guide us through what is important and how important is it for us to collaborate with all levels of government to ensure that it's not just writing laws, but also about its enforcement?
C'est toujours le nerf de la guerre. C'est comment.
That's the heart of the issue. How will we put these laws into effect? In terms of violence against women, training is a major part of the picture. If police agents were better trained, well, they would be more inclined to apply 811 in a domestic violence context. And they would understand that aggressors will use all possible means at their disposal to do coercive control, and that a breach of condition is a red flag. We must ensure that we apply the law as it exists in order to ensure safety. So training, the question of how we intervene with those who commit domestic violence. There are those who go to prison and continue to breach conditions. When 810 is applied, conditions must be extremely specific so that when there's a breach of condition, we can automatically apply, and I insist on the term automatically, 811. 811 should be the norm in that case. Thank you. Regarding the application of concrete measures, well, it could also be pertinent to add something to the criminal code that would be specific for domestic violence. So linking specific conditions to domestic violence context, that would allow us to better regulate 811, or rather, to better interact with 811. And evaluating the level of danger should be systematically applied. There's also an issue in terms of transparency of the data, not just in 810, but also the breach of conditions in 811. So that would entail documenting the gaps in what is done in those.
So, in your experience, where do you think that the administration of laws is lacking right now, especially when it comes to Section 810, when it comes to making sure that repeat offenders are kept away from their victims? Where's the administration of justice's lack right now? Are we talking about not enough space in prisons? Are we talking about judges and their lack of training, perhaps? I would really appreciate your insight.
Ben, fondamentalement, le 811, c'est un outil qui devrait d'abord être utilisé avec parcimonie. Parce que pas le 811, excusez-moi, le 810. Parce que c'est un ordre de garder la paix qui
Excuse me, one
oui.
moment, please. The translation is not working. Can we?
It's okay now. Hello. Fundamentally, 811 should apply because 810 is to maintain the peace. And it usually applies to someone who doesn't have a criminal record. For 811, it's not very useful because we often find breaches of conditions, and if one is to take them into account, it should be done under 811. And basically, 810 should be applied with very sparingly, because often in a tentative of attempted murder or even a threat, we also see in Quebec where there's a great cooperation and collaboration between the prosecution and the police. These instances, these events are very serious, and we have to proceed before a court rather than just applying an 810. It gives false security, a false sense of security for the victim. And it raises the entire question of proper training, of taking an awareness of the red flags in a situation, whether it's a prosecution or.
We only have like 20 seconds. Ms. Goudreau, do you want to add anything to that?
Madame Manassas aurait pu terminer
Well, Ms. Manassas would have completed it as well as I, but I think she told you the whole story. Good. Madame Larouche, 10 minutes and a half, 5 minutes and a half. Thank you very much, Madam Chair. I heard what you said. I hear you very well, and of course you would prefer the 811, and that you have to use 810 sparingly because it gives rise to false hope or senses of security. But we should have better tools to apply the law. You've also mentioned that. And in coercive control, for example, the reason that we're looking at this particular part of the criminal code is to see what's most effective and efficient for the witness. And I think if we were to use the conditions or the articles with coercive control, that would be even stronger medicine. Well, it would widen the scope of which offenses could be, to which it could be applied. Coercive control, very often, there's very little physical violence. And from a criminal sense, coercive control would allow us to, in fact, make it a criminal offense. And also assist in controlling psychological violence, emotional violence, over which there's very little response that's available in law. And we could use this in the cases of coercive control. Generally, we're dealing with physical violence. Continue, please. Well, for the context in which these offenses occur, they're very frequent, but sometimes it's an alternative instead of appearing before a court of law or having to testify, and they don't feel that they have enough support to come out in public. So various measures should be implemented in order to counter coercive control. The vulnerability of the victim, particularly from marginalized communities, whether indigenous or other. There's a lot of learning, teaching, or sensitization to do so that we understand the behaviors, the multiple repetitive incidents. We want to protect the victim, and these should be adapted to women who are subject to all forms of violence because they don't feel that they're being heard by the justice system.
Formation aussi.
Well, you talked about training the courts, the police, etc., which is obviously good. So how do we give back some sense of security to the victims? Very often, charges are not carried out because of they didn't respect any time delays, for example. It's been too long. Now, there's an ombudsman for victims of crime concerning the Jordan rule. Nothing is worse for a victim to see the suspension of a trial or a case. It protects the rights of the offender more than that of the witness, the victim or their family. Even sexual assault on children are sometimes suspended or postponed. So the Jordan decision, in fact, is counter to developing more security to women. Do you think we could, in fact, do something to control the use of the Jordan decision in order to give more hope and security to women? Well, when the Jordan decision comes into play, it's specialized legal courts that deal with it. Special politicians, prosecutors, lawyers who are specialists in. So it's within the justice system. We need special expertise, special teams, special courts if necessary, and they would do only that field of activity. This would, first of all, accelerate the judicial process, as is the case in Australia. 5 weeks is generally the norm that the case be heard. We know in Canada there have been very long delays, and the Jordan decision was meant to be a solution to that. But it's not very effective. And it really is quite a negative shock or disappointment to the victims. Well, there was one case where the offender was actually came back again and again, threatening the victim.
For 5 minutes.
Merci, Madame la Présidente. Thank you all for welcoming me to this committee. Je pratique mon français un peu.
I'll try to practice my French a bit. Before coming to Parliament, I was a prosecutor for BC.
I know Section 810 incredibly well. In fact, I'm going to say a couple of things about it. Section 810 is no longer protecting women. It is no longer protecting victims of intimate partner violence, in my view. Section 810, for those who aren't aware, is not a criminal offense. It's an allegation that somebody fears someone else, and it has to go through the court like any other charge. That means that there's disclosure, there's cross-examination, there's all these things. In British Columbia, we have a provision under the Family Law Act. What that does is it permits anybody who is fearful on reasonable grounds to apply to a court in what's called an ex parte manner. That means without notice. So the victim can literally appear in court tomorrow, say why they're afraid, then the person whom they're afraid of is served a copy of that order. They can challenge the order, and then it is a criminal offense to breach that order. That takes 1 day to get. A Section 810 peace bond can take up to a year to obtain, and then is only good for a year. And sometimes people will say, well, I've been good for a year, why are you even imposing this? So I think that that's actually something that we should be speaking about. I know a lot about this because of my background, but also because my wife is a lawyer, and my wife helps women who have been victims of intimate partner violence. And she echoes exactly what you've said, and I'm sorry for talking so much, but I do want to get this out, that breaches are no longer even responded to. There was a time when a breach of a contact order in an intimate partner violence setting was the most serious breach of bail. That is no longer the case. You have people who are victimized by breaches, and resources are so minimal that the police can't show up or don't show up, and victims are left in the dark. I have a lot more to say about intimate partner violence and Bailey's Law, but I'll stop there and get your thoughts, please. Thank you.
Merci beaucoup d'avoir bien.
Well, thank you very much for explaining all of the implementations and applications. This is why we're a little bit reluctant that use of 810. It's, in fact, recognizance. And as in BC, I'm very glad to hear that these recognizance orders are managed in a much more efficient way. Because if it's not applied, it's not worth the paper it's written on. When they get notice of an 810 order, they feel that it's going to be a safety net, and there's going to be consequences for breach of condition. But that's not the case. And also, whoever is doing the assessment or the evaluation of these breaches should be doing it under 811. And they are reluctant to apply them because, well, we'd have to be arresting offenders every day of the week. And but there's a systematic breach of conditions with some offenders. They just don't feel that they have to conform to the conditions. They just don't accept them, so they break them. So we need something that's much more rigorous, much more than 810. We don't really feel that 810 should be used as a generalized way. In a generalized way, it should, when women are violence against women is concerned, it should be 811. There are serious situations, for the most part. 810 should not apply when it's a serious.
Win for 5 minutes.
Thank you, Madam Chair. Merci beaucoup à notre témoin aujourd'hui pour être avec.
Thank you for today's witness for his appearance, and these are important discussions, important questions, and I'm going to switch to English because my French is not that solid.
Madame Goudreau, vous avez parlé, sorry, I said I was going to switch to English. You talked about the need for more data, that we don't really have some of the content and understanding of the landscape of how it's working. Could you talk about how that would help us to better inform the kinds of reforms and policy interventions that would make sense for us?
Oui, ben c'est sûr que pour nous, ben, l'enjeu premier, c'était l'accès.
Yes, well, our first concern, of course, is to get access to data because we wanted to know how many breaches occur in the last year, for example. We tried just for Quebec and we didn't get an answer. So there's a bit of a challenge right there. But in order to improve the police procedures, to get some more surety that they're going to deal with breaches, because, it might go on forever that we see women being defended, as it were, with an 810 ordinance. We have to document what's going on and out there in the real world, and it's going to be a way to improve police processes as well as to firm up the safety of society. Now, when there's an assessment as to the rate of risk or violence that an offender has, we don't want anyone to. We want to make sure that these breaches are dealt with in a serious fashion.
All recognize how challenging and systematic the levels of violence are for many women in our communities. One of the pieces that you have both touched on a bit was around 810 versus 811. Could you talk about if we were doing this right, or if the system was working well, what it would mean if we were using 811 in appropriate ways, and what would be required from in terms of the police to use that tool? You talked a bit about the training pieces, but I'd be curious to see what that meant in practice. In the ideal scenario, what that could look like in practice.
L'application du 811,
well, the use of 811 becomes a criminal offense, and that means that jail is always or detention is always possible, and this individual will be brought before a court of justice, not only for threats of death or attempted murder, but for breaches as well, breaches of condition. So this strengthens the feeling of security, the security net for the victim. It's very concerning when the coroner, during the postmortem, has found evidence of serious physical violence. And the perpetrator was, in fact, had many previous charges. So whether it's a coroner, a prosecutor, the police, everyone should be more or less coordinated in the way they deal with these breaches. You have homicide very often, or someone is driven to suicide, and was it useful to use 810 in such a case, rather than to start from the start to deal with breaches of condition which are serious ones under 811? It's all based, of course, on that assessment of violence. And so 810 doesn't want, under 810, perhaps a witness doesn't want to testify because she's not feeling secure. This is why 810 should be used very sparingly. But if it is to be used, it should automatically result in a serious control of the breach. Madame Larouche, I think.
Thank you very much, Chair. Thank you, ladies, for being here. It's shedding a lot of light on the issue. We can see the 810. Well, we really need to look into 810 and the false sense of security. We need to look for other solutions. You talked about 811, but you also spoke to the transparency and data collection. That's also in the Ombuds report. We're talking about the responsibility and the data. That data collection must be improved. We must do data collection in continuity, and the data must be reliable. That's very important. What would you have to add on that subject? You want to go? Go ahead. Quickly, and I'll let you wrap up. For us, it's systematic in the responses that we got from our members. They're police agents who systematically refuse to take domestic violence victims on. We need to know that so to understand exactly how many breaches of conditions there are within the context of domestic violence. We need to have the data in terms of the police response regarding notices of breach of conditions or requests for protection under 810. When we're working with women dealing with 810, when there are multiple breaches of conditions and they've tried multiple times to convince police agents, well, that's really something they should not have to do. On the ground, we're seeing that in all cases, often 811 isn't applied. So what's the point of 810 if we can't apply 811? When we work, because unfortunately we don't have access to the data, we rarely see 811 applied. That's really hellish for women. It can go on for years, breaches of conditions. Maybe it'll go on for multiple years, and it's just hellish because these women have to are continuing to be.
Now to Miss Cody for 5 minutes.
Hi there. I want to thank everyone for coming out today and talking to us. I know this is a really critical situation, as we've seen situations and crimes actually increase and the harm to women. Madame Saint-Pierre-Godot, last November at the Standing Committee on the Status of Women, you made some powerful statements. You said, and I quote, "Violence perpetrated online can lead to physical violence or even femicide. We must therefore find a way to intervene at the source." As we know that breaches are no longer responded to, nor does Section 810 work, I would like to hear your observation from the field.
Oui, ben c'est sûr que nos observations par rapport à l'augmentation des violences, ben on a en fait, vous avez comme moi probablement vu les derniers cas de féminicide qui ont.
The last cases of femicide that happened in 2024, there were 25 femicides. Currently, there are 16. The last cases of femicide, well, the aggressors had criminal histories. One of our main worries, the reason why we're here today, is to talk about risk assessment. of those who breach conditions, and also how the police take on these files and everyone who interacts with the victims. For us, there's really an issue in terms of risk assessment. We also made a proposal for recommendations before coming here. On top of risk assessment, well, on top of electronic bracelets, well, that should be systematically applied for those who are high-risk offenders, and that's applied in Quebec. And it's not a magic bullet, and it can create a sense of false safety. But high-risk cases must be better evaluated, and things need to be put in place concretely in order to protect women who are victims of violence and protect them against their aggressors. Manon, would you like to conclude? That's why risk assessment is key. We know that the number one red flag for the risk assessment is domestic violence in previous romantic relationships, and that's often the case. When we see those situations, and in the Quebec coroner's report, it's laid out in black and white. At that point, the possibility of femicide is extremely high. That's what we're seeing in the situations that we studied. So the issue of risk evaluation, unfortunately, before the courts, the offender can accept or refuse for a risk assessment to be done. I don't know if there's a way to say, well, it's a domestic violence context, sexual violence context, and we ought to be allowed to do a risk evaluation, which is really key to see if we should let the offender out on parole, if the offender is considered too dangerous.
I'd like to share the rest of my time with my member colleague here, Frank Caputo.
Thank you. I was particularly interested when you spoke about risk assessments because I have a law called Bailey's Law, Bill C-225. I'm not sure, I see one of you is nodding your head. Are you familiar with it? It responds to the killing of Bailey McCourt. I was very disappointed by the Liberals' tone when it was in the House of Commons because Bill C-225 builds within it a risk assessment at any stage of the proceedings. Right now, a person can only be brought before the court when they breach. Bill C-225 would allow a victim to apply for a risk assessment at any time in the proceedings. In other words, the person hasn't broken the law, but the red flags are there. Again, I see we have 4 Liberals in the room. I urge them to speak to their colleagues about this most fallacious position that they have put forward. I would like to put to you this idea of having a risk assessment and how important it is, and I would love your feedback on C-225. Thank you.
We completely agree that it is key for there to be a risk assessment. And it shouldn't be dependent on the will of the offender to agree or not. We should automatically be able to do a risk assessment. And as you said, we should continuously be able to undergo risk assessments through the whole process. Julie?
Now going to Madame Ménard for 5 minutes.
Merci, Madame la Présidente.
Thank you, Chair. Thank you, ladies. Unfortunately, our colleague, Mr. Caputo, will have to re-listen to your response because he wasn't able to catch it the first time. We need your expertise because in the fight against violence against women, the 3 levels of government must pull their weight. The federal government can act on the criminal code, applying laws. You both mentioned multiple times. What role can you see the federal government play? How can the federal government ensure that on the ground? Because as you both said, the law is there, perhaps it's imperfect, but the tools are there. And perhaps they are not being used to their full potential. Madame Goudreau, first you, and after Madame Monestis. We were also aware that we had just talked about 810 and the application of 810, and most issues were related to the police application of 810, so we know it's provincial. However, there are concrete measures that can be taken at the federal level to change certain conditions linked to 810. Be it, as I said earlier, having specific sections related to IPV and domestic violence. That's doable on behalf of the federal government in terms of specific conditions. That means that they are concretely named. They can be no contact orders, not being allowed to have guns. Those are factors that can identify situations where there's a high risk of femicide. So some conditions can be directly established in order to better protect women who are victims of this kind of violence and do a risk assessment. And once those conditions are put into place and it's linked to a specific IPV or domestic violence context, once those conditions are put into place, that means that the risk evaluation will be much easier to do by policemen. There's also a piece in terms of training and ensure that the rules are applied in a uniform manner. The first step on the federal level, well, that would be it. I also think that
the federal court should be trying to assist provinces in the enforcement of these criminal cases. Well, we confer with our colleagues throughout Canada in these shelters and transition homes. There's some practices which occur in Quebec, but not elsewhere. But the problem can exist, and we hope that the federal government could exercise their leadership and lead on the provincial or territorial enforcement of laws in provinces and territories in order to standardize and harmonize the particular police practices, for example, the risk assessment, for example. In some provinces, it works a lot better than in some others. It doesn't seem to be that good a tool in Quebec, but we need leadership, at least bilateral, if not multilateral, harmonization. We, as Julie was saying earlier, we need the statistics, we need the data to see where the system is broken and where we can, in fact, provide a suggestion of a proposal. You have about 30 seconds. I'd like to go and put me down for the next turn. Just a slight addition, if I may. It's not necessarily a tightening of the law, which is, or the sanctions imposed for a breach that concern us, if you will, but it's a better quality of the assessment itself with the tools that they have in hand. Not necessarily to get tough on crime all the time, and to have, more severe sentences or whatever. We just want the system to work better.
First panel for today, and so I'd like to thank our witnesses for their time and their testimony. We're going to suspend briefly while we bring in the next panel of witnesses and come right back. So thanks so much.
Merci beaucoup à vous.
Merci.
now to welcome our witnesses for the second panel. We have from the National Family and Survivors Circle, Hilda Anderson-Pierce. I hope I'm pronouncing that correctly. And we have from the National Police Federation, Brian Sauvé, who is the president. And with us by video conference, we have Rabatir, Marie-Claude Richet, avocate et directrice, et Catherine Ailot, avocate. Alors, for those that are on Zoom, if you want to choose your interpretation language at the bottom of your screen, you can pick English, French, or the floor, which gives you both. And please wait until I acknowledge you by name before you speak. And when you're not speaking, if you can please be on mute, that would be terrific. Those in the room, you know what you're doing. And so we're going to begin with the opening statements for 5 minutes. And I'm going to be ever so helpful. When you have 1 minute left, you'll see the 1 minute card. And when you have 30 seconds left, you will get the red card, just like in soccer. So I'll be ever so gentle at the end of your time to move us along so that we can begin the rounds of questions. And so we will start with Hilda Anderson-Pierce for 5 minutes.
Thank you, Madam Chair and members of the committee. My name is Hilda Anderson-Pierce. I'm the president of the National Family and Survivor Circle, Inc., an Indigenous-led and distinctions-based organization representing families of missing and murdered Indigenous women and girls, Two-Spirit, and gender-diverse people and survivors of gender and race-based violence. I honor all Indigenous women, girls, and 2S LGBTQIA+ people who are missing or whose lives have been taken far too soon, and for those who have experienced violence. I speak to the lived realities of Indigenous women and gender-diverse people across this country, realities shaped by systemic racism, colonial violence, and chronic failures across policing, corrections, and the courts. These failures are heightened in rural, remote, and northern communities, but they are present everywhere. The National Inquiry into Missing and Murdered Indigenous Women and Girls made this clear. The violence Indigenous women face is not accidental or isolated. It is structural. This is the foundation of Call for Justice 1.1, 1.7, and 1.10, which outline the core obligations of governments to create safety. These foundational calls guide all the reforms I will speak to today. Section 18 orders are intended to protect, but for many survivors, there are only protection on paper. Survivors describe being dismissed by police, minimized in court, or spoken to with racist and victim-blaming assumptions. These experiences violate the principles laid out in Call for Justice 5.4, which requires trauma-informed, culturally safe, and bias-free policing and justice responses. Even when a peace bond is issued, its effectiveness depends entirely on enforcement. The Office of the Correctional Investigator has documented chronic communication failures, inadequate release, planning, and a lack of survivor notification. These gaps are why Call for Justice 9.1 requires timely, reliable, survivor-centered information sharing. Without functioning systems behind them, peace bonds become symbolic rather than protective. The Sean Lam case, a clear warning. The recent statutory release of Sean Lam, who pleaded guilty to killing 2 Indigenous women in Winnipeg, demonstrates what happens when systems rely on conditions on paper but lack meaningful enforcement and oversight. Despite being assessed as high risk for intimate partner violence and sexual reoffending, Lam was released into community. Survivors and families expressed fear and rage, and rightfully so. The case underscores critical gaps, enforcement of conditions, communication between justice bodies, survivor notification, and community preparedness. These are precisely the issues highlighted in Call for Justice 16.27, which demands real accountability across policing, corrections, and the courts, and Call for Justice 1.10, which calls for transparent, coordinated systems that protect survivors and not endanger them. Survivors have told us time and time again what real safety requires, and each of these needs connects directly to the specific calls for justice. They tell us that safety begins with Indigenous-led, distinctions-based, wrapped-around supports, which exactly what Call for Justice 5.1 directs governments to provide. They tell us they need culturally safe, trauma-informed policing and justice responses. so that racism, stereotyping, and dismissive attitudes do not put them at further risk. This aligns directly with Call for Justice 5.4. Survivors also need reliable, timely, survivor-centered information sharing, especially around releases, breaches, and changes in conditions. That is a core requirement for Call for Justice 9.1. They need real accountability across policing, corrections, and the courts, so that no system and no institution can continue failing them without consequence. This comes directly from Call for Justice 16.27. And they remind us that safety must also include healing and rehabilitation for those who cause harm, something clearly laid out in Call for Justice 7.1 and 7.3. All these needs rest on the foundational human rights principles described in Call for Justice 1.1, 1.7, and 1.10. I propose 5 priorities. Recognize coercive control and pattern of harm, expand Section 1810 to cover coercive control, stalking, technology-enabled abuse and escalation that has not yet produced physical assault. Number 2, improve enforcement and policing capacity, create specialized intimate partner violence units servicing the Indigenous communities, set minimum staffing benchmarks for remote detachments, and mandate training on coercive control and colonial violence. Number 3, fix information sharing and survivor notifications, establish real-time integrated information sharing amongst police, courts, corrections, parole, Indigenous governments, and service providers with automatic survivor notifications for releases, breaches, and conditions changes. Number 4, reduce the burden on survivors, allow trusted third-party applications for orders, fund Indigenous court navigators and survivor advocates, provide legal aid, and ensure transportation and accessibility supports in remote regions. Number 5, Indigenous-led data and oversight. Collect distinctions-based data on orders, breaches, outcomes led by Indigenous organizations under OCAP principles, and use the data to set national standards and require accountability. In closing, this is not simply about amending one section of the criminal code. It is about transforming the systems that continue to fail Indigenous women, girls, 2S LGBTQIA plus people. Peace bonds alone do not create safety. Indigenous-led, rights-based, community-grounded systems create safety. The calls for justice tell us this. Survivors tell us this. Families tell us this. If Section 18 is to hold meaning, it must be strengthened through the structural reforms grounded in the inherent rights of Indigenous women.
Your 5 minutes is far over, and you can get the rest when we go to the questions. I'll turn now to Brian Sauvé for 5 minutes.
Thank you, Madam Chair. Thank you, members of the committee, for the invitation. I'm Brian Sauvé, a sergeant in the RCMP, also president of the National Police Federation of the Union, representing about 20,000 of our members across Canada. Women's safety, particularly from intimate partner violence, remains one of the most pressing and persistent challenges facing our country. Despite ongoing efforts and public awareness, too many women continue to live in fear or lose their lives at the hands of a partner or a former partner. According to Statistics Canada, in 2022, there were more than 117,000 victims of police-reported intimate partner violence. Nearly 8 in 10 were women and girls. Women disproportionately experience the most severe forms of this violence at rates 3 times higher than men. Section 810 of the Criminal Code plays a vital role. It allows law enforcement and courts to act before harm occurs by imposing conditions such as no contact orders or geographic conditions and restrictions. These peace bonds can literally save lives, especially when supported by consistent follow-up and enforcement. However, as our members see every day, legislation alone cannot protect victims. The effectiveness of Section 810 and of related reforms such as Bill C-75 and C-5 depend on adequate resources, timely communication, and coordinated enforcement. Without those, even the best laws risk falling short. We welcome the government's commitment to bring forward legislation this year to better address intimate partner violence, and we encourage that process to include meaningful consultation with law enforcement and survivors to ensure the legislation's intent translates into real-world protections. Based on our members' experience, there are 3 areas where we see improvements can be made. First, investments in effective monitoring and compliance systems. While Section 810 provides courts with the tools to set conditions, its success depends on how well those conditions are tracked and enforced. Currently, there is no single national database tracking Section 810 peace bonds or the related conditions. Provinces and territories need to invest in modern monitoring systems that allow police to track compliance in real time. Ontario's bail compliance dashboard is an excellent example. It gives officers quick access to an individual's bail status and conditions with intentions to be expanded to include intimate partner violence offenders. This type of system supports accountability and faster responses to breaches. Other provinces should look to Ontario's model as a best practice, incorporating electronic monitoring as enabled by Bill S-205, and integrating these systems nationally would strengthen enforcement and protect victims across jurisdictional lines. Second, modernizing privacy laws to enable information sharing. Effective monitoring and enforcement require more than just technology. They require the ability to share data securely and consistently. Currently, Canada's privacy laws limit how information about offenders can be shared across police services and jurisdictions. To truly protect women and children, governments should review and update their privacy frameworks to ensure that critical information about high-risk individuals can move with them between provinces and territories. This can and must be done while maintaining strong protections for personal information. Modern interoperable systems and updated privacy legislation will allow Section 810 to achieve its preventive purpose, ensuring that no matter where an offender moves, police and victims remain informed and protected. Third, resources and capacity. RCMP members work to enforce peace bonds, conduct compliance checks, and respond to breaches. Our members' workloads are heavy, particularly in rural and remote areas where one detachment with as few as 2 members may cover hundreds of kilometers. When a breach occurs and response is delayed because there are simply not enough police officers available, the sense of safety for victims erodes quickly. Although Canada's homicide rate declined in 2024, the number of women killed by intimate partners increased. Additionally, the proportion of women whose deaths were caused by a spouse or intimate partner rose from 32% in 2023 to 42% in 2024, about 7 times higher than men. And these are not just numbers. They're a stark reminder that without sustained investment in resources and victim support, Canadian women and children will continue to pay the price. Thank you. Subject to any questions you might have.
Thank you so much. Je cède maintenant la parole à Robert.
Merci. Alors, je suis...
Thank you very much. My name is Marie-Claude Richer. I'm a lawyer and director of Rebâtir. I was a friend of Lisette Corbeil for 47 years. Lisette was a victim of a femicide in 2021. This fatal act was the first act of violence committed against her. However, she had been a victim of coercive control for several years and had mentioned to police a few weeks prior to the murder that she feared for her safety, yet she was never offered the option of filing a request under 810 of the Code. I'm accompanied today by Catherine Ahelo, a lawyer specializing in criminal law. We are the only criminal law firm in Quebec that exclusively advises victims, and this everywhere in Quebec and in all kinds of law. The opinions and the positions expressed today are based on more than 22,000 victims assisted and more than 93 legal consultations provided. 93% of these victims are women. We understand the needs of victims so that they can better be protected by federal laws, which is why we're calling once again for coercive control to be recognized as a criminal offense in Canada. In addition to a deterrent effect, police and prosecutors could present this evidence in court, evidence of a spectrum of behaviors that limit another individual's freedom. This would give judges a more accurate picture of the situation and enable them to make informed decisions, which they are currently unable to do, given that they only have a snapshot of the behavior. Orders under 810 are intended to be preventative. However, in practice, this type of order in domestic violence context is almost always used to settle a case in which charges have already been laid. The accused will therefore be acquitted of a crime in exchange for a commitment. In reality, the victim wishes to obtain an 810 order as a preventive measure would encounter obstacles that make it virtually impossible or ineffective to resort to this measure. Victims who ask the police for an 810 order will be too often told that there is no criminal offense involved in this case, and they cannot submit their request to the Quebec Crown Prosecutor's Division, even if they are at risk factors for homicide. In this case, they have to file their request alone directly to the court. They could request representation by a lawyer, but since this is not covered by legal aid, vast majority will not be able to afford this. Representing oneself against a perpetrator is a major obstacle to this type of measure. Further, when the perpetrator is served with an 810 application, no safety net will be in place during the legal proceedings. Several weeks, often several months, may elapse between the time the proceedings are served and the 810 application being heard. Given the receiving legal procedures can increase the risk of homicide or further violence, this lack of conditions during the proceedings represents a long delay, constitute another major obstacle to the safety of the victim. Finally, the possible 12-month duration of an 810 order is not long enough to adequately protect victims in a domestic context. So we recommend several amendments to be very promising. It's essential that all murders of intimate partners, including femicides, be treated as first-degree murder, and murders of police officers are in the line of duty. We also believe it's essential to regulate the discretionary power of police officers to release individuals. We support to add paragraph 499, A and B. However, we believe that the list of offenses is too restrictive. The current proposals leave out several offenses that are very common in domestic violence. For example, if an individual immediately prior to an arrest was free under the terms of a release order, we should be using this application. The use of term immediately is vague and imprecise, doesn't capture the situation with breaches of conduct. Conditions may occur long after such conditions have been imposed. Further, it's essential that this measure apply when the person is subject to a condition issued as part of a police undertaking. Finally, we agree with the proposal to grant the court the power to order repeat offender risk assessment at any stage of the proceedings. Currently in Quebec, we have the option of conducting risk assessment at a bail hearing stage, but since this requires the consent of the accused, it greatly limits the effectiveness of such a matter. Thank you.
Round of questions, and we'll start with Madame Veen for 6 minutes.
Merci beaucoup, Madame la Présidente. Merci à chaque.
Thank you very much, Madam Chair, and I would like to thank the witnesses for appearing today. Now, we have so many questions that maybe we'll have to call them back for another turn, but our colleague, Madame Catherine, who was tabled a bill, 225, and if we can correct anything, for risk assessments to be mandatory if requested by the victim. And the perpetrator or the offender would not be able to refuse. Madame Richet, Madame Corinne Gagnon appeared earlier this week for the CAVAC network, and she was fairly harsh and very direct about the lack of effectiveness in 810. But for lack of anything better, it's going to be long. There's going to be delays. We use 810. But with 810, at least you can start with a procedure. But if you heard the network of shelters and transition houses, this is not effective. Now, today, we meet every day with women who live every day of their lives with a fear of violence and violence itself. Would you share the point of view of Madame Caron that 810 is used, but it's not a very effective tool? In fact, because we don't have the time to take other measures. So, yes, as Catherine was saying, and I'm going to pass her the word, who she's an expert in criminal law, even when a witness wants to be protected by an 810, if there's no criminal activity involved, the police will refuse to apply it. So the individual has to appear in person themselves to make the request of the court. And it will only be applied if there's some criminal activity that goes on. And the Crown sometimes will refuse to go with an 810 only when there has been some criminal activity and there's an opportunity or a probability of conviction. Now, that's where the problem is. Thank you very much. To end you, Mr. Shorey, what would you answer to women who have difficulty obtaining? I know we need resources. We need more modernized, up to date processes that deal with what's happening today, every day. Now, I'm not saying what. Maybe you're lacking resources, but you can't intervene quickly enough or early enough. What would you respond to that?
I will sit back and say that Section 810 is lacking, definitely lacking. As a police officer, it does not provide adequate protections. As a police officer, we do have police officers out there who will not take those applications, mainly because there's not enough time. And at the same time, I'll sit back and say this is not just the police. We're talking about federal, provincial, and territorial resources here, because we're talking about the number of Crown counsels, the number of court spaces available, the number of judges available that may not hear or may not entertain or may not want to entertain an application from a police officer on a file to apply for a peace bond. So there's a whole bunch of issues there that are blocking the effective use of Section 810.
Merci beaucoup, Monsieur Sauvé. Vous avez...
Thank you very much. You talked about C10 and C75 earlier. You went over that this is a good step, but it's not enough. There are a lot of detractors of C10 and C75. Maybe that made things a lot harder on the ground. Can you speak to that?
Well, I think I mentioned C5 and C75, but cautiously optimistic that C14 speaks to reverse onus bail provisions for domestic and intimate partner violence. So I'm looking forward to seeing how the future looks with respect to bail reform. Now, granted, that is post-offense, and we're talking here about how we can divert and make it safer pre-offense.
Merci, Monsieur Sauvé. Mesdames.
Thank you. Ladies, you heard about the Renault and the McCourt affairs in both cases. The families are asking that a register be put in place. A register of violent offenders. There's a register for sex offenders, if I remember correctly. They would like a domestic violence register. What do you think of that? Is that a good idea? Earlier, Mr. Sauvé spoke to information sharing. That's a bit similar. What is your opinion? As you mentioned, there is a sex offender registry. Having a domestic violence offender registry would perhaps protect victims more. We know that those offenders are problematic. At our organization, when a victim contacts us, the first thing we do is to look into his criminal history. And based on that information, our advice will...
So sorry, this is the hard part of the job. So we're going to go now to Ms. Nathan for 6 minutes. Thanks.
Thank you, Madam Chair. So I wanted to ask Hilda, the Indigenous women, girls, and two LGBTQ communities, people face disproportionately high rate of violence and systemic barriers when seeking protection. And you've mentioned that in your opening speech as well. So how should the federal reforms to bail, peace bond be adapted to reflect Indigenous rights, cultural safety, and lived realities?
You know, I think it's really critical that they engage with Indigenous women, girls, and Two-Spirit and gender diverse people and have them present, you know, and have equity in decision-making and resources at the table for their full participation to determine what this can look like from their lens, but also more so, like, you know, to fund, like, Indigenous initiatives, whether it be education, because many Indigenous women are not informed of what their rights are within the justice system as well. And often, you know, they're not respected either when they're trying to utilize these mechanisms and instruments and, you know, addressing like the systemic and structural racism that exists within, you know, these different mechanisms, whether it be policing, the justice system, and, you know, having policy and legislation developed around that as well, and, you know, fully embedding, you know, the specific calls for justice related to addressing these matters.
Thank you for that. And if I could go to the two people on the screen here, Catherine and Marie. You know that the government has introduced the Bill C-14 to strengthen bail and protect victims of intimate partner violence. From your experience supporting survivors through your organization, how do you see these proposed changes improve safety on the ground for women and gender diverse individuals fleeing violence? So comment specifically on Bill C-14 and how you see it applying.
Je te laisse aller, Catherine.
Catherine, I'll let you go. Yes, okay. What the victims on the ground need is that when they denounce a breach of condition, there to be an arrest and a detention so that down the road we can apply measures that already exist. That's a key point for victims in order to ensure their safety. At the moment, they denounce criminal offenses, then there's a breach of conditions, and afterwards, when she denounces again, they're not heard. And so then the offender isn't arrested. And so the victims lose faith in the justice system, and then they're not motivated to testify. That's a major issue for victims at the moment.
Has emphasized the need for cluster list or high-risk behavior to prevent femicide. What key indicators should be included, and how would your national legislative framework help front?
Excuse me for just one moment. I think we have a translation problem. Can we check? Can you hear me in English?
This is the interpreter. This is the interpreter on the English channel.
Okay, please continue.
on. Okay. So again, for Catherine and Marie. So your organization has emphasized the need for a cluster-list or high-risk behavior to prevent femicide. What key indicators should be included, and how would a national legislative framework help frontline organizations intervene sooner?
If I understand correctly, it's for femicide. Well, we think what ought to be included is the murder of any intimate partner. We don't want to distinguish between a man and a woman. That would be the criteria, murder of any intimate partner. We think it's important and essential to add including femicide and to include a definition of femicide. This would allow the recognition of the scourge of femicides.
One question, so I could probably ask Brian. The police are often first responders for racialized Black and Indigenous women who have historically faced deep mistrust in justice institutions. What training or structural changes would help ensure the bail, peace bond enforcement better protect the communities?
It was interesting. I was listening to Hilda earlier, and I went back to the previous government started a study of the First Nations Indigenous policing program off of this government. It has stalled. As part of that, we were consulted and asked to put in what we might recommend. There were a whole bunch of exactly what Hilda was saying, our recommendations to improve the First Nations Indigenous policing program, one of them being culturally sensitive training for our police officers, perhaps cultural liaisons within those Indigenous communities as police officers come in, longer postings, the ability to have refresher courses, the ability to really know what community bylaws are, to have consistency in that, because what we have seen, what our members have told us, is that constant transfers in and out, change of personnel with no consistency and knowledge in what the heritage is, what the bylaws are, or what the community is like. Everybody's different in Canada, which is one of the lovely things about this community we have, is that you end up with inconsistent application and lack of trust because you don't have consistent people there. So that's what I would probably recommend.
Thank you so much. That's the end of your time. And now, Madame LaRouche, 6 minutes.
Thank you, Chair. Thank you very much to our 4 witnesses who represent 3 different associations for participating today. It's very interesting. And that's happening during a week where we're hearing a lot come out regarding crimes in the context of domestic violence. Moreover, I have a question I would have liked to ask earlier to the previous witness, but I did not have time. Perhaps Rebâtir can tell me about the Institute ECHO. The Institute offers training. In your remarks, you spoke, like other witnesses, to the importance of the criminalization of coercive control, to recognize it officially, to enlarge the scope of the view of domestic violence. The ECHO Institute offers training in different sectors to allow people to recognize the signs of coercive control. Perhaps you could speak to that. And yes, it's all very well and good to recognize coercive control, but having the training to go with it, how can that help victims? Because here we're talking about Justice 810, and it doesn't seem to be all that effective. So how could the recognition of coercive control help? So the ECHO Institute is a Quebec initiative. They've already trained more than 8,000 legal stakeholders in Quebec on coercive control. Yes, we want to criminalize it, but we know that in order to detect it, we need to understand it. That's why this institute was put into place. to continue detecting coercive control. So for that people in the legal sector, social services sector, or the community sector, as well as police officers, understand coercive control. And when coercive control is criminalized, we'll be able to detect it and adequately create a file for the prosecutor and go to trial. That's what it's for. If I may, I saw the training, the positive effect of the training with police officers. That's my legal domain. I saw a progression in terms of how police officers treated victims, how they created their files, and the comments of the victims when I arrived in this organization in 2021. The victims' comments regarding police treatment was very, very negative, and now they're more positive. So I think training is key, and we need to work on training. During the parliamentary recess, I spoke to an MP who worked with your organization who said we can do a lot. But what's complicated is that the criminal code is federal, then the application is provincial. We have to remember that a report brought about electronic bracelets, innovation, but the question of the criminalization of coercive control, well, the MNA said, I cannot do anything, and the MNA did not understand that the federal government wasn't doing anything. So I tried to explain the issues. And so they asked us to criminalize coercive control in order to finish the report and complete the work that's done in Quebec. You talked about victims. Today, the Ombuds report on victims of criminal acts came out. There's an aspect at point 6, the declaration of the victim to prison services. Survivors, be they male or female, often have little information about their rights during and after the sentencing. They do not know that they have to sign up to obtain information on delinquency. The previous panel spoke about the importance of information sharing. What would you add to that Ombuds report? It makes all the difference for victims to be informed. At our organization, that's one of our roles, and we're trying to fill the gap. We try to share information between police, the prosecutors, the Crown, federal and provincial levels. And we try to take the time to explain to them that it can really reduce their anxiety level. It can help victims maintain trust in the justice system. Just a simple bit of information can make all the difference for the victim. As I have some time, Mr. Sauvé, what would you have to add regarding the importance of information sharing to victims?
That non-government organizations are the ones that are actually doing that. We should actually have governmental organizations that take it seriously and actually share information and protect victims and prosecute offenders when it need to be.
Thank you very much. Now we'll go to Ms. Cody for 5 minutes.
Again, I'd like to thank the witnesses for coming here today. It's a very important conversation. Mr. Sauvé, I want to quote you during one of your appearances before the Justice Committee last September, where you said, "They also see the human consequences of a system that often functions like a revolving door. They repeatedly arrest the same people, often for crimes committed while they were already on judicial interim release. This is both dangerous and demoralizing. It also drains police resources that could be more usefully deployed in crime prevention." As well, for his part, the Crown Prosecutor in Quebec, Maitre Alexis Denel, also shared his consternation regarding the judicial system. He sharply criticized Bill C-5, insisting on the obligation to be accountable to victims of sexual assault. So, faced with this record of failure, what are your thoughts on the importance of the federal government eliminating the principle of restraint in the bail release regime?
Bail reform is an interesting topic, and I'm glad it is getting the attention it so valuably deserves and Canadians have been asking for. One of the challenges that we have seen from a federal and a multi-jurisdictional police perspective is it is not just a federal responsibility. You know, the federal government can legislate changes to the criminal code, but that code is governed and administered provincially and territorially. So we have been trying to scream from the rooftops that all governments need to be working in tandem to do their part. So the principle of restraint is there. I really have no opinion on it. However, appropriately funded, appropriately resourced, appropriately educated, and standardized training for all levels of the justice system across Canada, I think, is desperately needed, and we all have to do our part.
Okay, Mr. Sauvé, we had a previous witness here. Her name is Debbie Henderson, and her niece was allegedly killed hours after her ex-partner's release from prison. And she recently told the committee that she is supportive of potential changes to the criminal code to make murder of an intimate partner first-degree murder. And so this would happen through Bill C-225, which was just recently introduced. So what are your thoughts on her recommendations to support Bill C-225 to reclassify intimate partner violence as first-degree murder?
It's hard to get charge approval for a first-degree murder offense. So, yeah, I'm interested to read the bill. Become more educated on it, and should that make it to committee, perhaps make a submission on it. But there are a lot of challenges with respect to getting a charge approval for that offense.
So would you say that our police actually possess all the necessary resources to enforce the conditions of Section 810 and ensure close monitoring of the transgressors? Like, what is your experience and thoughts related to intimate partner violence on electronic monitoring and GPS tracking devices?
So to answer your first question, no, we definitely don't have the resources. I don't think your courthouses have the resources. The sheriffs don't have the resources. Probation departments don't have the resources. And parole boards don't have the resources to adequately enforce any of those offenses. As far as 810s go and GPS monitoring devices, I think we need to embrace technology. I think we really need to figure out how we can do better with whether it's judicial interim release or whether it is bail or whether it is post-parole or whether it is a Section 810 that's entered into by consent, and how we ensure that probable offenders or actual offenders are actually complying with those conditions, so we don't end up in that revolving door where you end up arresting the same person, because perhaps if you have jurisdictional information sharing of those who have breached, then maybe a judge in Calgary will know that an offender in Vancouver violated their conditions numerous times and entered into a stay of proceedings for those violations to plead guilty to the substantive charge. Right now, they don't know that because they don't share that information. It's maintained within the courthouse database.
I'm going to change a little bit.
And that's the end of your time.
Okay,
I'm sorry. We're going to go now to Ms. Khalid for 5 minutes.
Thank you very much, and thank you to the witnesses for appearing today. Mr. Sauvé, in your opening remarks, you had talked about the importance of modernizing privacy laws. Can you expand on that a little bit? Why do we need to modernize our privacy laws?
It's been my experience, for example, that a victim of domestic violence may want to distance themselves from their offender. How do we ensure their protection? How do we ensure that that move, that location, where they move to, Vancouver to Calgary, Regina to Saskatoon, Montreal to Quebec City, Toronto to Huntsville, is protected? Whether that is through the court proceeding, the ultimate court proceeding, if we're vetting, we're redacting, we're ensuring that locations, data, and all of that stuff about victims is protected so that offenders, court registries, a very select few people are available and knowledgeable about that information. That helps protect the victim. Social media has become a challenge. The shrinkage of the world with respect to that has become a challenge. So how do we maintain protection of those victims who choose to get out of a city, a location, or wherever to get away from their offender, and their family members as well, supporting that, whether they're children, sisters, brothers, mothers, fathers.
Thank you for that. And I know you touched on this a little bit with earlier questioning, but with respect to sharing information between jurisdictions, why do you think that's necessary, and where does privacy laws play into it?
This has a lot to do with bail reform. So, for example, as a national organization, the RCMP, you know, if we're dealing with someone who's been charged with domestic violence, whether it's assault causing bodily harm, doesn't matter, and they're placed on conditions and they violate their recognizance 5, 10, 8, 12 times before things go to trial. Our experience has been that a plea or a guilty verdict for the substantive charge of assault or assault causing will probably result in all of those breaches or those violations of a recognizance going away to a stay of proceedings. So now your offender is going to do their time or serve their sentence, probation in the community, or provincial custodial sentence, or sometimes federally, depending how serious it is. And when they get out, should they reoffend in a different jurisdiction? So, for example, the first one was in Calgary, the second one might be in Regina. The fact that they violated the recognizance on the first offense is not known to the prosecutors or the justices in the second offense, because it's maintained in that provincial court database, which is not shared with the other province. So that information could be very important to a police officer who's preparing a Crown package for bail, but it could also be very important to a JJP or a judge who is hearing that bail hearing and a Crown counsel who's making the argument. Not having that information kind of leaves them blind.
Thank you very much. And lastly, I'll ask you, you spoke about prosecution and the lack of resources and the shared responsibility amongst all levels of government in ensuring the safety of women and the enforcement of law. In your opinion, then, what do you think we can do at the federal level to make sure that provinces are better supported? And then also, if you can touch on the whole concept of prevention versus prosecution, and where are dollars most effective to be spent?
I'm really looking forward to learning more about this ECHO project. I've got it in my notes here to go look more, because, you know, is that an initiative that we can undertake and convince the RCMP to do some training on? I think that would be fantastic. I'm always looking for, I'm the union guy, so more training is always good. But as far as, I think, a leadership role from the federal government to garner all provinces and territories on board to sit back and say, you know what, we got a problem here. How can we get together to work together to improve Section 810, whether it's reporting requirements, whether it's GPS, whether it's monitoring, whether it's staffing levels, whether it's whatever. Let's figure out how we can work together on this one, because it's a shared responsibility.
Thank you very much. I really appreciate that. That's all, Chair.
Excellent. La parole est à vous, Madame Larouche, 2 minutes et demie.
The floor is yours, Madame Larouche. You have 2.5 minutes. Well, thank you very much, Chair. I don't know if we'll have another round of questions, but in your preliminary comments, you explained very clearly the specific issues and problems of Indigenous groups, communities, women in particular, of course. Now, in the Ombudsman's report, as to service of orders, those who are in a long distance away, remote areas, etc., have very, very many difficulties, extra difficulties, in obtaining an order or a request of the courts. Now, what would be your first reaction to my statement, first of all, and anything to propose to resolve it?
First and foremost, we know that, like, when we're looking at remote isolated areas, they do not have the infrastructure to support technology, and that's very problematic, because if they had the infrastructure to support the technology, we could ultimately save lives. And when you're looking at the revolving door of policing, you know, and also a lot of inexperienced officers going into remote isolated communities, and if women are trying to obtain protection orders, or even if there is, you know, often there's no RCMP in the community to enforce that protection order, so that ultimately puts Indigenous women at further risk to continue to experience violence or to die as a result of a homicide. So, you know, it's really critical that we look at this, and, you know, we really look at even, you know, there's a lot of dialogue about jurisdictional boundaries as well. And that's critical, you know, because when you're looking at, you know, First Nation communities, they're federally regulated, right? And then you're looking at, but they're also like embedded within the province. So it's quite complex when you're looking at it. And I think we really need to look at the resources and, you know, how Indigenous women, you know, are being failed in these communities repeatedly. And I think it's critical, you know, that we really align with the specific calls for justice to really protect them and keep them alive ultimately, and keep them safe.
Thank you so much. And now, Madame Vienne. 5 minutes, 5 minutes.
Thank you very much, Madam Chair, and thank you for the witnesses for being here. I do proudly have DEPL in my riding in Regina Louvain, so I am the MP of the home of the RCMP and training. And coincidentally, we met with the National Federation of Police, some of your colleagues, a couple weeks ago. And we've talked about resources a lot in this meeting, and resources needed. There has been a commitment to hiring 1,000 new officers, which would help on the streets and help keep people safe. My wonder is, from your books, it says that's going to cost $200 million. Is that budgeted in your current RSMP budget?
Well, it's not my budget, but I won't speak for the commissioner as to how he spends his money. However, it's my understanding that extra 1,000 over the next 4 years that the government is committed to in the budget is part of that $1.8 billion investment into the RCMP, including an increase to the cadet training allowance to make the RCMP a more attractive employer during their training time.
Thank you. Another request from your guys' budget submission was $62.5 million to add 500 RCMP special constables by 2028. Do you know how much headway, if any, has been made on that to add to the resources for keeping our communities across the country safer?
From the federal perspective, I'm not sure if we've succeeded on that yet. However, I do know that different jurisdictions, such as Nova Scotia, British Columbia, who are committing to renewing their contracts beyond 2032, are fascinated by the idea of the utilization of a special constable category where, and for those who aren't familiar, you know, in the RCMP, you have the gun and badge-toting constable, you have the badge-toting special constable, and then you have the neither of the two civilian support staff. The utilization of the special constable category is, for example, could be more used in a ban bylaw situation or in a major event situation where you're just walk and don't walk, you're standing here for security versus having a completely armed police officer. So we've been advocating for that for the RCMP, and I know there is an appetite from the RCMP to revisit and look at how they classify their positions. So hence we've been pushing the federal government to revisit that and invest in it.
Thank you very much for that. I am very interested in the data sharing aspect of this, and I think it's a huge gap in our policing, the fact that we can't share across interprovincial borders what if a crime's been committed by someone in a different province. What would be, and I know you have $1 billion ask in here for public-private partners for public safety and create a broadband network, and that's a very big ask. But I think the timing is, how long would it take to get something up and running where you could share that data interprovincially. Is there anything that you could add on to right now, or would you have to basically start a project like that from scratch?
If I take the easy way, I would say you could probably do it fairly quickly because the Canadian Police Information Centre already exists. All police services have access to it. The RCMP obviously maintains it. However, it does need modernization, and maybe we change the parameters of how CPIC works and what can be included in CPIC. Right now, if I query someone on CPIC, all I'm getting is their convictions and charges outstanding, not necessarily what was stayed. And
that was my question because I have my PAL, so I get run through CPIC, I think, daily to make sure that I haven't committed a crime so that my possession and acquisition license stays valid. So how would you be able to add past crimes to that so that then that could be used? Could that be used then for police forces to check up on if they've committed crimes in their jurisdictions?
That's probably where the privacy lawyers are going to get involved, and they'll give you some recommendations as to how you can get around that hurdle. I can only say it's a records database, and we can probably improve that records database that's accessible to all police across all jurisdictions.
Thank you. Appreciate the job you guys do.
Very good. And now for our last round of questions to Madame Menard and whoever you care to share your time with.
Merci, Madame la Présidente.
Thank you very much, Chair. I have 4 questions. I hope I have the time to ask all of them. In order to multiply our responses, Ms. Alejo and Mr. Wade, you had comments on murder between intimate partners. Now, we've heard hypothetically that this could mean that in a scenario of legitimate defense, the woman might be accused of a first-degree murder. This is what we find in 225. This is why the Liberals are having a problem with that. I'd be very interested in hearing Ms. Anderson-Pierce on this matter, this possibility. What would you respond to that?
It could be dangerous, especially if a woman is protecting herself, during intimate partner violence, and we know that as Indigenous women, we experience a lot of injustice in the justice system, and often when we're expressing our lived experiences and our realities, we're ignored and we're dismissed. And especially if our partner is non-Indigenous, they tend to believe him or her over us as Indigenous women because, of the systemic and structural racism that's deeply embedded in policing and the justice system. So, there's a big risk factor there for us. So thank you.
Oui. Quant à vous, est-ce que...
So, from your point of view, do you think that this is a generalized response that you would get? Well, an individual could find herself accused, and legitimate defense could nonetheless be applied. Now, just because there's a murder in a certain situation, it doesn't mean that there's any intent there. It's a legitimate defense. If this is applied to this person, she's entitled to that defense.
I mean, a crime is a crime is a crime, whether it's in self-defense or not. So from a policing perspective, we would still have to investigate, and should something come of it, obviously make a recommendation, and then it's in the court's hands.
Merci. À plusieurs reprises...
Frequently, we've heard from other witnesses the role of leadership for the federal government. We understand what we mean by that, but nonetheless, it's very hard to actually end up with a real process to ensure leadership. What role could the federal government play here? Well, I've discussed this with Minister Fraser.
Oui, je parle français. C'est juste, je vais te donner les...
Well, I do speak French, but It's easier for me and more accurate if I answer you in English directly.
Is convene a meeting of all the attorney generals. Let's convene a meeting of judges. Let's convene. Let's get a consistent training manual for crown counsels. Let's get consistent training for judicial justices of the peace, so that the application of the criminal code in a jurisdiction for the intent of the offense, or the reverse onus provision, or the bail provision, is actually consistent across Canada. That's what I mean by taking a leadership perspective, right? Somebody has to take the ball and start running.
Il me reste quelques secondes peut-être.
A few seconds. One more minute. Mr. Sauvé, I'll end with my last question to you. We're looking for what do you think about the result of training, specific training for police officers? What are you looking for?
It's always a better result, whether we're talking about training about mental health. We're talking about there was a topic a little while ago about when CEWs first came out, and excited delirium, training about that, learning about that, being aware of that. There's training about domestic and intimate partner violence. So the more training, the more education that your police officers get, the better. The trauma-informed approach is now fairly informed now. It's getting better. The more we can do to inform our frontline paramedics, firefighters, police officers, and those that deal with people in the first instance, the better the service delivery will become.
Thank you so much. That's a great place to conclude our meeting today. I want to thank the witnesses for appearing. Your contributions are much appreciated and very helpful to us. And for the committee, just to let you know that we're getting together on Monday. We only have one of the witnesses that we've called that's willing to come. So we're actually going to put that witness in the Wednesday panel. We'll start with committee business on Monday. So I think that there's a couple motions on that we've given notice, and there's the scheduling of the ministers, which have agreed to come.
Okay, so it'll be in camera then?
Yeah. Perfect. We'll see you Monday. Meeting adjourned.